Good morning. Hello, everyone, and thank you for attending today's webinar, Tariff Trends 2025, Experts' Insights on the New U.S. Customs Landscape. My name is Rachel Dean, and I'm a Senior Trade Advisory Associate here at Flexport. We have a lot of content to cover, but before we begin, I'd like to go over a few housekeeping items. On your screen, you will see a sidebar to the right of the main stage where you can submit questions. At the end of the presentation, we will host a Q&A and answer a few of the audience's questions. So be sure to get your questions in early. In the same sidebar, you will see a tab labeled Documents or Docs. This is where you can download a copy of today's slides and find other helpful resources. Above your screen, you have a button to request an ACE analysis from Flexport. We will review in further detail later in the presentation, but please click that button if you would like Flexport to reach out to discuss an ACE analysis for your business. Now, a brief legal note. Please keep in mind that all information provided in this session is based on the situation at this current time and may not be customized to your specific business requirements. We always recommend reaching out to a Flexport expert to discuss your particular situation. Joining me today is my colleague Marcus Eeman, who is a director at Customs here at Flexport. And on the agenda today, I will be discussing some of the latest news, some IEEPA updates, legal challenges to IEEPA, and then I'm going to turn it over to Marcus, who will discuss tariff stacking, hot topics, and then we'll dive into some Q&A if you have any questions. So, on to the latest news. Now, we did do a presentation a few weeks ago, so these are updates since our last webinar. So, one of the big updates is the new tariffs on India. On August 6th, the President issued an executive order imposing secondary IEEPA tariffs of 25% on goods from India in connection with India's Russian oil imports. The tariffs took effect on August 27th. There are exclusions to these IEEPA tariffs, and there's kind of a trend when you see exclusions to all the various IEEPA actions. There is kind of a similarity in the exclusions that they have. So there's an exclusion for existing or future 232 tariff actions. There is an annex to an executive order 14257, which was modified by an executive order on September 5th, which I'll be diving into a little bit deeper later in the webinar. And there is an exclusion for humanitarian aid covered by 50 U.S.C. 1702B. Now, please note these 25% Russian oil secondary tariffs against India are in addition to the other IEEPA duty that is already imposed on India. It's a little bit of that tariff stacking that Marcus is going to dive into later. Also, in latest news, we have the U.S.-Japan agreement. On September 4th, the President issued an executive order implementing the U.S.-Japan agreement, which establishes a minimum combined tariff rate for Japanese goods of 15%. This is very similar to the agreement we saw with the EU. So let's kind of run through a few little scenarios here. If your column 1, so your normal trade relation duty rate, is greater than 15%, then there is not going to be an additional reciprocal duty applied. In column 1, your normal trade relations duty rate, if it is free, then the reciprocal duty rate will be 15%. And then if the column 1 normal trade relations duty rate is anything under 15%, the reciprocal duty rate will be whatever it takes to bring it up to the 15%. So if your column 1 duty rate is 5%, then the reciprocal duty rate will be 10%. Again, we're seeing trends in how these are applied, again, similar to the EU. So this order has a lot of exceptions and exempts certain products, and it's got a lot of caveats, and we'll see a trend with this when we look at the executive order that the President issued on September 5th. But it does exempt certain steel, aluminum, and copper products covered by the WTO agreement on civil aircrafts. It caps combined Section 232 and NTR rates of duty on automobiles and auto parts subject to the 232 tariffs under Proclamation 10908. There's a lot of different executive orders and proclamations and things like that. So when you go through the documents later, you can reference them. And it authorizes the Secretary of Commerce to reduce the reciprocal tariff rate to 0 for natural resources unavailable in the United States, for generic pharmaceuticals, generic pharmaceutical ingredients, and generic pharmaceutical precursors. Now, also, an update is under the 232. There are several investigations that are still pending from March and April for like lumber and pharmaceutical, but recently there's been a investigation for wind turbines and parts initiated as of August 13th. The thing to keep in mind when we talk about 232, again, we have IEEPA, which are completely separate from the 232. And typically when the 232s come into effect, it's very fast. With the copper, 50% on copper that went into effect, it only took 3 days from the executive order to when the additional duties were imposed. So you need to keep tabs on everything that's going on with the Section 232s as well. And now to IEEPA updates. I had mentioned earlier that there had been a executive order on September 5th that went into effect on September 8th, and it is modifying the scope of the IEEPA reciprocal tariffs. So these are the tariffs that went into effect in April worldwide. Now, it's also establishing procedures for implementing new trade and security agreements pursuant to the executive order. This executive order has added additional items to the list of items that were already receiving the reciprocal duties. So previously, aluminum hydroxide, resin, and silicone products had been excluded from the reciprocal tariffs, but they are now going to be subject to those. And then it also, this executive order removed some of the items that had been subject to the reciprocal tariff. So bullion-related items, so gold, certain critical minerals and pharmaceutical products are now in Annex 2 and excluded from the reciprocal IEEPA tariffs. And something new in this executive order is a Annex 3, which is not applicable to any of the countries yet, but it's creating a framework to provide 0 reciprocal tariff rates for certain products from countries that have negotiated agreements with the United States. Now, we know there have been UK, EU, Japan, they have agreements. Those agreements predated this executive order, and they are not receiving the benefits of Annex 3, even though you'll see kind of similarities in the language and the things that are exempted. So in this Annex 3, we see that natural resources which cannot be grown, mined, or naturally produced in the United States, certain agricultural products, my beloved coffee, aircraft and aircraft parts, and non-patented articles in the use of pharmaceutical applications. There was a lot of information in this executive order. It also empowers customs to issue refunds when a trade agreement has been put in place. It also empowers the USTR and the Secretary of Commerce to be more active in implementing and negotiating trade agreements. So, which is great. We want to see these go through more quickly so we can get our applicable duty rates down. So, next. And this is something I know that's been heavy in the news, covered greatly. And this is the legal challenges to IEEPA. So this year, since January of 2025, President Trump has imposed 4 separate tariff actions under IEEPA. Under the litigation, only 2 of them are covered. We have IEEPA fentanyl. Now, these are the duties that are applied to all Chinese goods and then non-USMCA Canadian and Mexican goods. And then the tariffs, the reciprocal tariffs that are worldwide that went into effect in April are also covered by this litigation. The other ones, for example, that are being imposed on India or Brazil are not covered by this litigation. And these are the cases that are going before the Supreme Court the first week of November. Now, here are the main arguments that we're seeing in these cases. Number one, side of an umbrella of the plaintiff's argument is that there's no authority under IEEPA for the president to issue any tariffs. Or conversely, that if there is some sort of authority under IEEPA, it's not authorizing the tariffs that have been put in place for fentanyl or for the worldwide. So there are additional cases that are pending in the district courts, which are just at a stay until these decisions are made at the Supreme Court level. Now, it's interesting because some of the arguments have that the CIT, in these two CIT cases, the court held that the worldwide tariffs exceeds the legal scope of the president's authority and are contrary to law, since they would require interpreting IEEPA to give the president tariff authority that is unbounded by any limitation or duration in scope. The CIT also held that IEEPA authorizes the president to take action only to deal with an unusual and extraordinary threat with respect to the national emergency declared and not for any other purpose. The court interpreted the words "to deal with" to require a direct link between the actions taken and the problem that it purports to address. So that's specifically when we're talking about fentanyl. Are these fentanyl tariffs dealing with the actual crisis or emergency? And then we're going to go to the next slide here. This is I'm going to cover this slide at a very high level. It's got a lot of great information that you might want to go through later. This is the argument that the CIT lays out to say that the president's IEEPA tariffs are not legal. And it kind of goes through a whole history of how the word regulate is used in legislation regarding the president's ability to impose tariffs. So the major takeaway here is that, one, there's a precedence for the court to determine that the word regulate authorizes the president to issue tariffs, but that in such cases, the tariffs were specific and connected to the identified issue, meaning when we look to the 1971 proclamation with Nixon, the Nixon tariffs were there to address a balance of payments, but the tariffs were temporary and had a maximum combined rate of 10%, plus the normal trade relations duties. And in response to the duties that Nixon put in place in 1971, Congress responded and came back and limited them under the National Emergencies Act of 1976, and then further limited the president's power to impose tariffs under the International Emergency Economic Powers Act of 1977. When we always say IEEPA. It's the International Emergencies Economic Powers Act of 1977 here. And some of the language that we see in that legislation is that Congress is giving the power to, or delegating the authority to the president to investigate, regulate, or prohibit any transaction in foreign exchange. So when we talk about the government's argument, it's hinging on that interpretation of what regulate means. IEEPA further provides that these authorities may only be exercised to deal with an unusual and extraordinary threat with respect to which a national emergency has been declared for the purposes of this chapter and may not be exercised for any other purpose. So that is kind of the history of the president's authority and legislation that the CIT laid out in the VOS selections case that is in front of the Supreme Court right now. And on the next slide here, what are the potential outcomes of the cases before the Supreme Court? Well, first off, it's whether IEEPA authorizes the president to impose any tariffs at all. Then secondly, if the tariffs are authorized, whether IEEPA authorizes these specifically tariffs that have been implemented. So does it authorize the fentanyl tariffs? Is it authorizing these broad scope of worldwide tariffs that have been imposed? And then lastly, which court has the jurisdiction to hear these cases? Is it the CIT? Is it the Court of International Trade? Now, here are some of the potential outcomes. At a high level, quickly, the Supreme Court can come back and say there is no authority for the president to issue any tariffs under IEEPA. So could strike that down. And hopefully then the CBP would have to refund any of the invalid tariffs that were collected during that time period. Secondly, IEEPA could authorize the president to impose tariffs, but it might be limited. So it may say that some of these tariffs are authorized, but it needs to be limited in language. And in making that decision, it could remand the case to a lower court for review. It could find that only certain elements of the tariffs are legal and strike down the rest of the language. And it might establish parameters that provide boundaries on the use of IEEPA's authority. The court may decide the case solely on jurisdictional basis or remand the case to lower courts for review. And currently, the cases are following two separate tracks. We have the Court of International Trade, and we also have the district courts. So what is this going to mean for you as an importer and protecting your interest in these duties that you've been paying in this year? So we know that there's been a lot of advice. We've seen it on news articles, we've seen it on LinkedIn, we've seen it on social media, whatever. But there's a lot of talk about trying to extend your liquidation dates to protect your interest in these tariffs, the refunds on the IEEPA tariffs that you've spent in this year. Now, there are a couple of things to consider with this. In general, you should always keep tabs on the liquidation dates of your entries, just so you know what's happening with some of them. But you have to be careful because I'm sure several of you have had to increase your bond values. You may have even had to put down collateral. And there may be a possibility that if you leave the liquidation dates open for these IEEPA tariffs that you've been paying in, that it'll increase the value that needs to be covered by your bond. So it may affect your bond. So that's something you would have to take into consideration. You're also going to need to monitor your entry liquidation dates very closely because as we mentioned earlier with the IEEPA update and also when we were talking about Japan, there's a potential for US Customs to proactively issue refunds for the difference in duties that were paid in when they're rolling out these new trade agreements. And when they issue those refunds, they're going to liquidate your entries. And what is that going to do for any potential post-statement correction or protest or any sort of effort that you take to claw back the money that you paid in for all of IEEPA, not just the ones that were for the IEEPA duties, for the fentanyl and reciprocal, not just the difference in the trade agreements that have been implemented by the president. As an importer, if an entry is liquidated, you can also file a protest. This is 180 days from the date of liquidation. So again, monitor your liquidation date, make sure that you get the protest in. There's something to kind of keep in mind when we're talking about the court case and how it affects the refunds on these IEEPA duties, is in the court's decision, they can also state the relief is only going to be provided to the parties of the litigation. So you would need to seek legal counsel to see if you can get your duties refunded on that. You would need to reach out to those trade professionals to protect your interest. Again, we don't know that's going to be in November. Well, let me put a caveat to that. The Supreme Court is hearing the case in November, but that does not mean that the decision will be issued in November. Just because they're hearing it, they can take weeks or months, or they may wait until the next session before they issue an opinion on it. We would hope because they're expediting it that they would issue an opinion more quickly, but it's not a given. So in this last column, consider legal action again, because if it's only the parties to the legal actions, then you're going to need to speak with an attorney, a trade attorney, and protect your interest in recouping those IEEPA tariffs. Now, with that overview, I am going to turn it over to Marcus to discuss tariff stacking.
Thank you, Rachel. Yep. All right. So I took a little bit of this section here to kind of talk about the tariff stacking, because I think every time we get into Q&A, there's always a ton of questions about, okay, wait, with this, if this is true, then how else does this, tariff apply, or when does this exemption work, or what is the in-transit date, or all this other stuff here. So I look back at the last two webinars, some of their questions that they had come through with, some of the ones that people had been asking, and it's like, okay, let's go over maybe a few kind of use cases, emails that I've gotten. Let's go over a few cases here and just talk about maybe some of the top highlights for some of the tariff stacking measures here, and just how do these all work. So I'm gonna start at the top left here, if there's an item that's flagging for 232 duties on automotive parts, 232 duties on steel, 232 duties on aluminum, if an item's HTS is on all three lists and it is an automotive part, the automotive 232 applies. So that's 25% versus the steel or aluminum's 50%. I'm thinking this kind of stuff are like some of the bumpers and fenders of 8708. But if it's not subject to the automotive tariffs, either because maybe because USMCA is claimed potentially, maybe because it's not for a passenger vehicle or light truck. Maybe it's for a heavy truck. Maybe it's for some other kind of vehicle that is not a passenger vehicle or light truck. Then you do apply the 232 exemption code from the automotive tariffs, and you pay the steel 232 duties instead, of which is 50%. Okay, second one, Brazil. So if it's something is Brazilian origin and there's no other exclusions at play, there are two tariff codes that you apply for Brazilian origin. There's a 10% code, which is the IEEPA rate. That was part of Liberation Day, and then the augmented, or the change to Liberation Day in August, where they adjusted the rates. Brazil has a 10% Liberation Day reciprocal rate, but they also have a 40% specific rate pertaining to some other sort of trade disputes that was also pursuant to IEEPA. So you apply both of them if the item is from Brazil. But if within that 40%, there was something called Annex 1. These are specific HTS codes that were exempted for Brazil, namely like orange juice, Brazil nuts, some of those agricultural products, some of those commodities that are unavailable natural resources. If it is on the Annex 1, then just the 10% list applies. So if it's just on Brazil Annex 1, you don't apply that 40%, only the 10% IEEPA reciprocal applies. But if it's on IEEPA Annex 2, then only the 40% applies, not the 10%. So the 40% would still apply, but not the 10%. Okay. India, 25% plus 25%. So India's IEEPA reciprocal rate was 25%, but it also gets another 25% because India is a big buyer of Russian oil. So this applies to all products of India. But if the HTS is on Annex 2 for reciprocal tariffs, neither the IEEPA nor the Russian oil 25% apply. So you go, if it's on Annex 2, you don't pay either of those 25% categories, you pay 0% there. So normal duties notwithstanding. If you are paying 232 on the value of the content, neither IEEPA nor the Russian oil 25% apply to the value of the 232 material content either. Okay. Fourth one, I mentioned this just a little bit above here, but USMCA for auto and steel. So if it flags for both and is claimed under USMCA, then you exempt the 232 duties for USMCA. But the IEEPA fentanyl, the auto 232 is exempt because of the disclaim that's allowed for USMCA claims on auto parts. And IEEPA fentanyl is also exempted because there's an exemption code for that. But the 232 duties on steel still apply. So interestingly, by claiming USMCA, you kind of aren't really going to save all that much on some of these like auto and steel parts. Fifth, this is kind of something that was a little tucked into the Russian aluminum order here. So you may know that if you import Russian aluminum, you use a different code for Section 232 on aluminum. If any of the Russian aluminum used in that imported product was smelted or cast in Russia, you use a 200% code. But what you maybe have missed is that the 200% applies to the entire value of the article, not just the value of the aluminum, right? So if you have aluminum that's not Russian origin, and you have a flagging HTS code for 232 duties, you're allowed to break out the value and just pay 50% on the value of the aluminum alone. The way that the Russian 200% rules are written is that you pay the 200% on the entire value of the product, even if it contains a very small amount of Russian aluminum. So just one quick notice there. And the last one here, U.S. origin products. This has actually changed a little bit based on a ruling. It was back at the end of July, but it just got published in Cross a few weeks ago, is that U.S. origin goods are not subject to the 10% all country IEEPA rate, which sort of made sense, but was not made explicit, right? The reciprocal tariff said, the 99030125 applies to any country not specified with its own rate below. Well, the US is a country, so that would sound like any country. Does it apply or not? Customs did clarify in this recent ruling that the 10% does not apply to US origin goods, whether or not you claim it under a 9801 US goods returned or some other potential tariff provision. Also, if you are importing US tariffs as well, or even if it's not US origin, don't forget your potential for a 9903-0134 claim, which allows you to deduct out the value of US origin content, assuming there's at least 20% US content in the imported article. Okay, so those are a few common questions here. And if you're trying to be like, okay, Marcus, like this is all great, but I can only write it down so fast. I'm not going to want to look at your webinar every time. That's really why we came across and built our tariff simulator tool. I know we've done a ton of webinars here. This one is not going to be a webinar with a demo of the tariff simulator. I want you to explore it for yourself. It's tariffs@flexport.com. It keeps track of all these scenarios that I just talked about for you. It makes it easy to understand all this stuff. You don't have to copy and paste this slide down and then just be like, okay, what do I have to do here? There's no complicated flow charts to figure out. Just input your tariff information, countries of origin, values, any SPI claims here, and it'll do some of these calculations for you. So that question about Canadian steel, automotive parts, how does that actually work? Like, well, here we can show you how. If you have a steel bumper, you can even modify the aluminum or steel content in that bumper. So tariffs@flexport.com. Please play around with it, give us feedback. It continues to be improved upon. We're adding more things every day, more MPF, more SPI programs are being supported. So please take a look at it. I do want to close with a few other kind of hot topics. I know Rachel sort of opened up this session talking about the news, kind of what is happening or what has happened recently, and she obviously had a lot to talk about the court cases. Okay, what do I do with that? There is a new modification. There's this new things changing to Annex 2. There's the Annex 3, which hasn't gone into effect yet, but gives us hope for the future that maybe there'll be some duty savings coming. But what else is kind of maybe just around the corner? I think one I want to talk about is the CPSC e-filing. This is the PGA, which I know has kind of gotten, definitely been co-pilot to all the tariff news here. But this is kind of a little bit of a wake-up call. If you haven't heard about the CPSC e-filing changes here, the short version is that CPSC data elements are now going to be collected, and they're going to be reported in entries. And this affects about 2,500 HTS codes, which is quite a lot of consumer products, as the name suggests, right? Consumer Product Safety Commission. They're looking at clothing. They're looking at consumer electronics. They're looking at bicycles. They're looking at furniture. They're looking at a lot of things that you may be importing today, a lot of consumer goods that are imported today. And I'm sure because you are all excellent, 100% compliant importers, every one of you has your general certificates of conformity or child product certificates for CPSC review, should they ever request them. Well, now that if you have those all in place, that's great, but this now has to be uploaded into the e-filing system for CPSC to be prepared for mandatory filing starting July of next year. The reason why I'm bringing this up now is we were getting feedback that a lot of the work that's taken to do this is usually on the importer, and it can take several months of time. We're talking 1 or 2 employees to find all these general certificates of conformity, SKU numbers, and then uploading it into a database on CPSC's side so that they can review it at the time of entry. Now, every broker is going to have to be doing this by July 8th, but most of the work is not on the brokerage side. Most of the work is actually on the importer side. So this is something that as you start to go into next year's planning, you may be starting to wonder about headcount. This is maybe something where you might want to have a temp support. You may want to find some other people to pull together to find all this, start to talk to some of your product people, and make sure you get these certifications in place. 1 week from today, there's an office hour with CPSC to talk about e-filing. Anybody's free to attend. It's open to the public. In the handout that you'll be getting after this webinar is a link there to that meeting. And there's also, I was told verbally, but it's not on their calendar, that there should also be another call October 29th as well. So watch out for that one. Second piece of big news is USMCA is being reviewed. And this is kind of the first review. It first went into force in July of 2020. That's when it was officially adopted. And there was a first review that was going to happen 6 years later. Well, that review is going to start in July of 2026. This is a review between Canada, Mexico, and the United States. They talked about, hey, how's the free trade agreement going? Is it working? Are we happy with it? And so before that meeting happens, the U.S. Trade Representative is collecting comments for the next 45 days up through November 1st about what do you think? What do you in the importing community think about USMCA? Is it good? Is it working? Is it helpful? Is it burdensome? What would you want to have change about it? They want to see all those pieces of information. So comments, feedback, anything about how difficult or easy it is to maintain compliance. And if you're a small business, identify that in the comments. They have a mandate to look for that very specifically and look at that feedback very closely. And I mistyped it here. It's not the regulations.gov. This is actually on the comments.ustr.gov, comments.ustr.gov. That is the case number, though, the USTR 2025-004. That is the case number, the docket where you can upload documentation. You can also upload business confidential information that won't be visible to the public. But take a look at this now. If USMCA is something that you care a lot about, is something that you benefit from and have benefited from, please do that. Okay. Finally, postal entries. We did a de minimis call a couple weeks ago, but if you hadn't heard, right, we all know de minimis is now gone. There are a couple of replacements for it. Postal entries are maybe the closest equivalent to it. At first, a lot of post offices stopped delivering all parcels to the United States. They all pulled back. Now we're starting to see a slow trickle of postal services resending packages to the United States now that they know how to figure it out. They're finding partners. They're learning how to pay some of these duties, either at the country of origin's IEEPA rate or a flat fee. But just a quick point of emphasis here, that flat fee does end at January 30th, 2026. If you missed that, it said that you can only use this flat fee method for 6 months from the date of the order. Date of the order was July 30, should be ending around Jan 30 for the flat fee. Otherwise, it'll be the country of origin IEEPA rate. So COO and value will need to be reported on this. And I would say, if anything, on the postal entries, expect just a few more changes here. Postal entries, for the time being, avoid 232 duties, avoid anti-dumping entries, the Brazilian 40%, the Indian oil tariffs. Those aren't being collected yet because they're all based on the IEEPA reciprocal rates. So this is something that I think the administration may be aware of. They maybe look to change it up. They say, hey, this is just another version of that de minimis loophole. We're going to look to change it. So do expect more updates on postal entries. This probably isn't going to be set. They're going to keep finding ways to tinker with it and make sure that they're protecting the revenue of the United States. And the second part of this is that there's going to be high penalties associated with it. The One Big Beautiful Bill established penalties for violations of this, starting at 5,000 up to 10,000 per parcel, per violative parcel. So if people are starting to cheat some of the rules, we could see some pretty heavy penalties coming down for these postal entries. So that also may start to change behavior or the rhythms on the provider side as they start to see penalties potentially from the government. So that are some of the hot topics that we're watching here. But let's go into some of the things that you wanted to find out about. Oh yeah, we have our tariffs.flexport.com, our ACE analysis tool. Click the button at the top of the screen. And if you have questions about classification or other kind of advisory services, if you're curious about the protest process or extending liquidations, this is definitely something our advisory team can support with here. Feel free to please access these links and reach out. So, like I said, those are the topics that I was wondering about. But what are the topics that maybe you're wondering about? So, Rachel, are you able to come back here? Let's go through maybe a few questions that we got. Let's see. All right. So the first one for you, Rachel. If the Supreme Court were to agree with the lower court's decisions and find that the IEEPA tariffs were illegal when they hear the case in November, would that only overturn the IEEPA fentanyl tariffs on China, Canada, Mexico, or would it also overturn the IEEPA reciprocal tariffs? We have heard differing opinions on this question. And Classic, you are on mute.
Of course. There we go. There's no guarantee that the Supreme Court's decision will provide relief to importers that are not party to the case. The cases challenge IEEPA reciprocal and fentanyl tariffs. So that means that the other IEEPA, so against Brazil, the Indian, Russian oil tariffs that are the secondary IEEPAs, those aren't part of this case. So those aren't up for issue. So it just depends. Like, let's hear what the Supreme Court says. Is it going to be more, is the decision going to benefit all of the individuals that have been paying in on IEEPA tariffs? We'll see.
Yeah,
It depends.
I
There's no
have I
guarantee.
have to imagine though, right? So if they decide that like the IEEPA did not give the president authority to levy tariffs, those secondary tariffs on India and Brazil are probably on pretty shaky ground at that
I would,
point, right? And so maybe it doesn't go back to the Supreme Court, but maybe at a lower court level, those may look pretty weak. Should the IEEPA tariffs be struck down in the way the plaintiffs want? Yeah,
I would hope. Yeah, if
yeah,
they decide that IEEPA or not, yeah.
yeah.
With that
Um, Let's see. Are there any 232 exemptions for the country of origin U.S. for aluminum, steel, copper? All right. Yes, many and overlapping. The way the for 232 for both aluminum and steel, uh, aluminum and steel smelted or melted or poured or cast material can be exempted from the 232 duties, but be expected to prove it. Be expected to be asked a lot of questions about where was it done, mill certificates, POs that were issued by the manufacturer to the U.S. steel mill or aluminum mill, back to the country where it was made. So there are exemptions for this here. On the FAQ for the 232 website, as of yesterday, CBP still had it there. I checked because somebody else asked. They did say, hey, if the country of origin is US, do I have to pay 232 duties? The answer, the one-word answer CBP gave in their FAQ was no. So if country of origin of the product, the place where the goods were last substantially transformed is US, no, you don't have to claim 232 duties even if the steel isn't from there. Third one, when it comes to copper, in contrast to aluminum and steel, there was no aluminum production exemption for copper. The copper came with two codes. One was for applying the copper 50%, and one was saying use this code if this line doesn't have copper content. It doesn't have this third one that says, oh, what if the copper is from the US? So that seems to potentially have been an oversight on the part of the USTR. Maybe this is something they're corrected, but oddly enough, copper doesn't have that same US production breakout that either steel or aluminum does. So the answer is yes, but which flavor of US exemption are you looking for? Okay. Did you say that, Rachel, just to clarify, did you say that tariffs on India is not part of the litigation heard by the Supreme Court?
It's not part of the litigation. The only ones are the worldwide, well, the reciprocal that are worldwide. So those the tariffs against India, yes, but not the Russian oil.
Okay.
Like we discussed a few minutes ago, we were talking about like if they just strike it down in its entirety, IEEPA, then potentially everything will crumble. Well, hopefully everything will crumble down, but that's not part of the litigation.
Yeah. Okay. How do we do this for extending entry liquidation versus filing protests? For extending entry liquidation, that's something that is done with the C, which is the Center of Excellence and Expertise of CBP for the Port of Entry. Or I'm sorry, not the Port of Entry, for the C. They can extend liquidation, but it's kind of their choice. So this isn't necessarily something that they do. There's also something where they may say, yes, we agree to extend liquidation. And we've seen cases, if you were around for the 301 tariffs in 2018, 2019, 2020, 2021, there were cases when CBP said, oh, yes, we'll certainly extend liquidation. Oh, and whoopsies, we clicked the wrong button. And no, we aren't going to reset it for you. So extending liquidation is haphazard, is a little bit imperfect. So that is a great scenario. But as Rachel mentioned, there's maybe a bond consideration there. And there's also just an operational consideration there. Does CBP even want to do it? And if they do want to do it, are they actually going to do it? Makes extending liquidation a little bit less likely. Protests are something that you can potentially do on your own as an importer. But the reason why I think there's value in getting professional support is because you are agreeing to put your entries under a very fine-tooth comb. You're going to ask for a lot of money back potentially from customs. And before they give you a lot of money back, usually people look at it. I don't know if this is still the case, but back in 2018, the old standard was if there was a refund amount of over $25,000, it had to be reviewed by at least two people at CBP before they would give you that refund for over $25,000. So did you make sure your HTS classifications were right? Are there any other considerations here that maybe you want to make sure your I's are dotted, your T's are crossed? Are there any other potential issues with your entries that maybe you want to correct? Because if you have to correct anything else, this may be your one chance. So it's important to make sure you're not looking to go too fast with some of these protests. It's important to keep them open, right, if you want to protect yourself, but it's also important to have like maybe a second set of eyes just to make sure, okay, yes, we're going to keep open our opportunity to get refunds, but two, I don't want to wake up into a new compliance situation because we missed this other thing while we were rushing to get protest filed. So with that, just certainly would recommend reaching out to Rachel and her team for protest support. Rachel, a question for you. Can an exporter claim a refund of tariffs from CBP if the contract terms called for the exporter to pay them, like DDP?
It's whoever the importer of record is. So if it is DDP and it's the shipper, then they're the ones who are entitled to the refunds. There's a lot of considerations when we look at DDP terms. So if you're a party in the US and you've decided to switch over to DDP, if there is a decision and if the Supreme Court decides that the IEEPA or tariffs are not valid or permissible, those refunds are going to go to who paid them. So under DDP terms, those are going to go back to the exporter or the shipper overseas.
Yeah, I think that's another important kind of question if people are considering DDP, right? It's like, if you're going to pay DDP, you're probably paying more for your goods than you were before. And the reason you're paying more for those goods than you were before is because of these tariffs. But if the tariffs are now refunded, they don't come back to you. Like, you don't get a refund of this, they go back to the importer. So you paid more for the tariffs. Your DDP seller gets the refund, and you have unless you have a really tight contract, there's no way for you to kind of get any of that money back. So you paid a higher price, and the reason you paid a higher price is because of money that you'll never get back in the event the IEEPA is refunded. So a good kind of another warning there for DDP. Good call out. Yeah. Yep. Is there a typical liquidation time frame for when it comes to imports? I was under the impression that it's 314 days. Yes, it is the closest Friday to 314 days from the date of customs release, of cargo release. And it even, like, practically it's actually a little bit shorter than that because they don't want to liquidate within 2 weeks of that day. So it may be even a little bit sooner, closer to 300 than 314. But yes, 314 days is the normal liquidation cycle. But if liquidation just basically means that CBP reviewed it. So if CBP reviews it earlier, they may liquidate it sooner. So if you filed a PSC for some reason, you had to correct some other issue, it may liquidate sooner. If they issued a CF-28 and it was totally fine and you replied with the information, CBP said, hey, this looks great, thanks for being compliant, and they close it, well, they just did a review of that entry. And so they may send it, okay, click liquidate instead. So they may schedule it for liquidation sooner. Maybe they reviewed it without sending a CF-28. Well, then they could still also liquidate it sooner as well. Liquidation, CBP has a lot of control over that, and it's a system that's not easily reversed. So if they do set things for liquidation, it's not something that can easily be done. Thesis of the question, yes, 314 days is the generally applicable timeline between cargo release and liquidation. Yeah.
Yeah, and a call out again back to when we were talking about the U.S.-Japan agreement. If Customs goes back and retroactively issues refunds for those IEEPA tariffs from August 7th on, they're going to liquidate those entries and issue the refund. So there's a lot of things that can cause it to liquidate sooner than that timeline.
That too. Yeah. Yep. And I guess we'll have to see on Japan if they decide to do a manual liquidation or an automatic reliquidation or refund. I would really hope they're testing out an automatic refund, because if the court case goes in favor of the plaintiffs, that would be great. That'd make it a lot easier. No protest for anybody, just refunds, checks coming down in the mail. But that could be tricky. So yeah. All right. Will we get IEEPA refunds only if we protest in advance, or will we be able to file protest after the ruling is decided to get the funds back? That's a good question. Rachel.
It depends on what the court decides.
Yeah.
Have a good relationship with your trade professionals. Reach out, pay attention to your liquidation dates, and just hold tight. We don't know yet. So
yeah. Okay.
possible.
So
we hope.
So the most conservative, the most protective answer would be to file them before the court case is decided, right?
Correct. Yeah.
Okay. But we also know that, depending on this, right, the tariffs didn't start until February, give or take, of this past year. And then if you take the 314-day liquidation cycle plus the 180 days to file a protest, that gets you to about early June of 2026 before where like the protest deadline would be. So in theory, there's maybe a little bit of time after the fact, right? But maybe not that much time after the fact, right? So you really don't want to be under the gun. So it is definitely kind of a balancing act about how much do you want to be protective, conservative, how much do you want to say, okay, maybe this will be an automatic process. And it ultimately depends. I think the biggest question is like, how quickly does the Supreme Court decide? Is this something that they, release a decision in January, or is it something where they release a decision with the rest of the June dump of decisions? It's kind of a bit unknown there. Yeah. Okay. Let's see. Do you have a list or search of the HTS codes impacted by CPSC e-filing requirement? Yes, I do. It was hyperlinked in the presentation that y'all will be getting a copy of after this webinar. Let's see. Maybe we'll do one more here. For you, Rachel, if you want to wrap it up, with regard to Annex 2 and the potential agricultural products being exempt if a country makes a deal with the USA, let's see, could you detail this a little bit further about maybe coconut oil from the Philippines is a product that cannot be grown in the US, but the tariff tool still reflects 19%. So I guess maybe the question here is, if there is some sort of like agricultural deal with the United States, when will we see any kind of refund or applicability? I think maybe one part of that question here is the tariff tool doesn't reflect the 19%. I'd say like at least that is because that coconut oil was on Annex 3. Annex 3 hasn't been implemented yet. It's been drafted, it was released, but it doesn't say it applies to these countries on this date. That has not yet been released. We're kind of guessing at it, but we don't update our tariff tool until we have official guidance. We don't update our tariff tool based on rumor. So I think then for this one, Rachel, I guess maybe the bigger question is like, do you know what maybe the government's maybe looking for to determine who qualifies for that Annex 3, the unavailable natural resources? Do you have any other kind of guidance there?
No, the only thing I would call out is in that executive order, there was language empowering the USTR, the Secretary of Commerce. There's obviously a push to facilitate more of these trade agreements to go through. And having that Annex 3 where they can easily reach out and say, okay, you get the benefit of Annex 3, kind of like as an incentive for the countries that are negotiating with the United States on these reciprocal tariffs. Again, Annex 3 is not applicable, like you said, but it's kind of a tool for the USTR secretary, like as we're pushing these through to kind of grease the wheels, maybe? That's kind of how I see it. That executive order in general is a lot of things to kind of like push things along, letting customs proactively issue refunds. But no, there are several agricultural products that are listed in that Annex 3. There's a lot of items that are listed in that Annex 3, but and you can look at it. I mean, it's available. If you pull up that executive order, you can see what's listed, but it's not in effect now for any of the countries, and we're hopeful.
Yep.
So.
Okay. All right. Well, with that, everybody, that will conclude today's webinar. Thanks so much for attending. We will send a follow-up email to the recording and to the slides tomorrow morning. Have a wonderful day.